there have been numerous legal démarches, rulings, opinions, orders over the course of the last year. It's not for want of legal processes that Israel's attack on Gaza is ongoing. It is the failure by the international community to uphold those rulings, to comply with them, and to adhere to their obligations under international law. But I'm going to set out briefly the 4 key processes that have occurred or are ongoing this year in relation to Gaza and in relation to Palestine more broadly. The first is, of course, the International Court of Justice's advisory opinion handed down in July, a seminal opinion that makes clear that Israel is occupying the Palestinian territory, that is unlawful, that it must be brought to an end as soon as possible. And the United Nations General Assembly has, of course, said that that means within 12 months of September, so by September of next year, that it is in violation of the right of Palestinians to self-determination, that the settlements must be dismantled and settlers repatriated to Israel, that Israel is in violation of Article 3 of the Convention for the Elimination of Racial Discrimination, which prohibits segregation and apartheid, and there must be restitution and reparation for Palestinians. But equally importantly, what the advisory opinion makes clear is that third states are under an obligation not to recognize as lawful Israel's presence in the occupied territory, duty not to render aid or assistance to Israel in maintaining or entrenching its presence in the occupied Palestinian territory. Critically, a duty to distinguish in their dealings between the territory of the State of Israel and the occupied territories, and a duty to cooperate with the United Nations to bring the occupation to an end as soon as possible. So that is an absolutely critical and seminal opinion by the International Court of Justice. There have been 2 other cases before the International Court of Justice, 2 contentious cases. The first is South Africa versus Israel, in which I was instructed, in relation to which the court found that there was a real and imminent risk of prejudice to the rights of Palestinians not to be subjected to acts of genocide. And having found that risk, the court ordered 3 sets of provisional measures against Israel, with which Israel is required to comply. And they include to ensure, for example, humanitarian aid to Gaza, to allow fact-finding missions into Gaza, and to ensure that the Israeli military does not commit acts of genocide, including killing and harm. Equally seminal, but sometimes overlooked, is the case of Nicaragua versus Germany, which is critical because it looks at the obligations of third states, in particular Germany, in relation to the aid and assistance or complicity by Germany in what Israel is doing in Gaza. And whilst the court didn't order provisional measures in that case, it did make some very, very clear pronouncements. It took the opportunity to reiterate the obligations on third states under Common Article 1 of the Geneva Conventions to ensure that the Geneva Conventions are upheld even in conflicts where the state in question is not itself a party, and also the duty to prevent genocide. And what is so important and so interesting about that ruling is that the court saw it particularly important to remind states of their obligation relating to the transfer of arms to states involved in a conflict where there is a risk of violation of the Geneva Conventions or the Genocide Conventions, and the court made clear that they apply in the context of Israel's attacks on Gaza. And then finally, as you will all know, there are the arrest warrants that have rather belatedly, but at last, been issued by the International Criminal Court, including a warrant for the arrest of Benjamin Netanyahu, the Prime Minister of Israel, for war crimes and crimes against humanity, including starvation. So there is not a problem in the sense of there are legal processes, they are being implemented, they are being sought, but the difficulty is, and the critical problem that is facing not just the international institutions, but also the international legal order at present, is the failure by states to comply with those rulings and the failure by the international community to ensure that they are upheld, that has really led to a crisis point at present for international law.
So you have sketched out, the word of the war has been unprecedented right from the moment. There is so much that is unprecedented about this war, and so too on the legal front. Would you agree that unprecedented, that so many of the world's top courts, so many of the sharpest legal tools the international community have been wielded, but as you've hinted, they haven't really moved the dial. They haven't achieved what they're intended to achieve, which is justice. They've been mocked, they've been ignored, the courts themselves are not recognized by all the world powers. Briefly, do you have any other legal tools in your toolbox?
So I have just come here actually from the Assembly of State Parties to the Rome Statute of the International Criminal Court. It was being held this week in The Hague. It was a bleak and somber affair. You had the President of the International Criminal Court addressing the Assembly of State Parties, talking about the extraordinary and unprecedented situation facing the court, the coercive measures, threats, sabotage against the court, which she described as being an existential threat to the court. And it's very difficult to disagree with that assessment, but not only that assessment as it applies to the International Criminal Court, but to the international legal order as a whole. And it's in significant part, as I said before, due to the failure by the international community to seek to hold Israel accountable for what it is doing in Gaza. There is more that can be done. There are 5 things that I will set out very briefly that can be done, because now really is the moment for states, for international lawyers, for civil society to push back, to try and ensure that the international legal order, the international rule of law is not trampled upon, but comes out stronger, because the future, any alternative future is where what is happening in Gaza is normalized, is frankly too bleak to contemplate.
Just list, because we're going to have to get on
so
to
very quickly, states can redouble their commitment to international law, number 1. They can intervene in the cases that are currently before the court, South Africa versus Israel, Nicaragua versus Germany, also Gambia, Myanmar. It's not about Gaza, but it is about the Genocide Convention, and it will determine the interpretation of the Genocide Convention going forward. They can bring forward further advisory opinions. Norway is indeed spearheading an initiative at the United Nations General Assembly in relation to the unprecedented attacks on UNRWA. Lawyers in domestic jurisdictions can bring cases. I myself am involved in a case in the United Kingdom challenging the UK's continuing exports of parts for fighter jets to Israel. And of course, it is not just about weapons. The advisory opinion, paragraphs 278 and 279, are clear that states need to reevaluate their dealings with Israel, whether they be cultural, military, political, economic, to ensure that they are not, in their dealings, upholding the illegalities.
Thank you very much.